on your time zone. Hi, everybody. Depending on your time zone, I hope you enjoyed your lunch or your morning or your middle of the night coffee. My name is indeed Frederik. I'm a lawyer, but very interested in computer science, but not educated in computer science at all. What I know, I've learned from computer science colleagues and my own study, basically. I propose that we do questions at the end of the talk, but I'm going to try to explain about the law to you, which is a new discipline. So it makes sense, of course, if you have questions. I'm going to discuss how the law in Europe can protect people when machine learning or AI systems have discriminatory effects. And I'm going to focus on the two most relevant fields of law, namely non-discrimination law and data protection law. In the latest installment, the GDPR is the most famous statute in data protection law. But first, I'm going to give two examples that help us later to understand the legal rules. This is 9 years ago already now. This is the first hard evidence that online stores, at least some online stores, engage in price differentiation. So some stores charge different consumers different prices for the same good or service. A research team, including Ashkan Soltani, a very good computer scientist, did pretty much a scientific test on a very large scale. They visited online stores from different IP addresses, from thousands of different IP addresses. And indeed, it turned out that stores charge different prices based on the location of the consumer, because as you know, the store can, in most cases, can guess our location on the basis of our IP address. And the researchers also checked whether they could understand why the prices were like that. And they found out that if a consumer has an IP address that shows that the consumer lives in a big city with many stores around, then the online store will show lower prices. And that makes sense because let's say that you're shopping for a washing machine and you look at an online store and you see the price, but you know that in your street there are different stores, and if they are cheaper, then you would close your laptop and go outside to buy the washing machine. So the online stores offer cheap prices if you live in the city, basically. That is good. So price competition works even online. So if you live in the city, that's good news for you because that's how the market is supposed to work. However, if you live in the countryside in the United States, and that's a big country, some people have to drive hours and hours for the closest shop. If you live in such a village, then the online stores will charge you high prices because most people will not drive hours and hours for a discount of $50 or something. So bad news if you live in the countryside. And it is extra bad news because on average, people in the countryside in the US are poorer than in cities. So you see that the pricing scheme leads to higher prices for poor people. Next example. Similar, Princeton Review is a company that offers extra lessons to high school kids over video calls like we are having now. And parents that hope their kid goes to MIT or Harvard or Princeton can buy extra lessons from Princeton Review, online coaching basically. And at Princeton Review, you have to, at that website, you have to fill in your postal code and then you get the price. And it turned out that neighborhoods where many people of Asian descent live, so for instance with grandparents or ancestors from Japan or China or Korea, they pay higher prices. Now we move to the law. Firstly, non-discrimination law and in European non-discrimination law. An important difference to keep in mind is the difference between direct discrimination and indirect discrimination. People from the US may have heard about disparate treatment. That's the US word for direct discrimination. And disparate impact is the US word, American word for indirect discrimination. Direct discrimination is how they used to do, for instance, in South Africa. So openly saying this area is only for white people. And sadly, this kind of open discrimination still happens in the Netherlands and in Europe too. Sometimes there's, for instance, companies that say we will not hire people with an immigrant background. And some clubs, discotheques, basically never let anybody in with a dark skin color. So it happens, and it would be really easy to build direct discrimination into an AI system. For instance, just delete all the job applications from women. It's easy, but not the most common problem in AI. There's also indirect discrimination. This is much more nuanced and complicated and more relevant for AI. I'm summarizing the definition in bullet points. And it's really painful for a lawyer because we like being precise with the language. But I'm going to explain it, and later on I'm going to apply it on a case. Hopefully then it becomes clear. So indirect discrimination is if there's an apparently neutral practice that ends up harming people with a certain ethnicity or gender or sexual preference, etc. In principle, that is banned too. So a neutral practice that has the effect of discriminating. Banned in principle, but we'll see that there are exceptions. Oops. And for indirect discrimination, it is not relevant whether it happens by accident or on purpose. So even if a company hires another company, an AI developer, for instance, to select job application letters, and they didn't mean to, but it turns out that they are discriminating against women by accident, the company can still be fined, because for indirect discrimination, it doesn't matter whether you meant to or not. Now, let's apply the definition to this US situation. Is there a neutral practice? Well, yes, because Princeton Review did not ask, please fill in your skin color and then we will give you the prize. No, Princeton Review asked, please fill in your postal code and then you get the prize. So yes, this would count as a neutral practice. Next question, does it harm a certain ethnic group? Well, yes, because people with an Asian background pay higher prices. So banned in principle. And now we are going to get an exception, and a quite complicated exception. Namely, if the neutral practice has a legitimate aim, and that neutral practice is a proportionate way of aiming for that legitimate aim, for trying to achieve that aim, then the indirect discrimination is not prohibited. Complicated, I know, but hopefully it becomes clearer after we apply it. First question is making profit a legitimate aim or profit maximization? Because let's assume that Princeton Review only wanted to make extra profit. Well, I'm pretty sure that the judge would say, yes, profit maximization is a legitimate aim. For instance, in Europe, there's a social market economy, nevertheless, a market economy, and judges and policymakers like capitalism. So I think it fits in the legal system to say, yes, aiming for profit is legitimate. The next question, this is typically for legal thinking, especially in Europe, is that neutral practice, so the price differentiation, is that a proportionate way of aiming for more profit? Normal people talk about reasonableness mostly. You can see proportionate roughly as a synonym for reasonable. So is price differentiation a reasonable way of aiming for more profit? Well, typical lawyer answer of me, it depends. It's complicated. I think that all the circumstances should be considered of a situation. And by the way, there is no case law. There are no judgments by courts yet on such price differentiation. So I'm kind of guessing here, but I'm guessing it by interpreting other case law. Anyways, for instance, I think for price differentiation, to see whether it is proportionate, I think it is relevant what type of product we're talking about. In the Netherlands, for instance, pretty much all families buy bread every day. So if you pay higher prices for bread, that people feel that every day in their wallet. However, let's say that the company is selling caviar. Most families never buy caviar. So that would make it less problematic, I think. And I think also the price difference is relevant. Are we talking about 3 cents or about hundreds of euros? And we can think of more factors to consider. For instance, does the seller have a monopoly position, etc., etc. So back to the ban on indirect discrimination, element 1 and 2 are easily answered. So there's a neutral practice and it harms people with a certain skin color. Yes, yes. And then we get that complicated exception, like does the company have a legitimate aim, and is their behavior proportionate or reasonable? A nuanced rule, but somewhat complicated. And this brings me to a couple of weak points in non-discrimination law. One weak point is that such automated discrimination may remain hidden. You may not know that you are the victim. For instance, let's say that you are a parent and you're paying extra lessons for your kid in high school. You may not know that other parents pay a different price. And even if you speak to another parent and you hear they pay a different price, you may think, well, that's perhaps because they buy French lessons and I bought mathematics lessons. And even if they buy exactly the same amount, etc., then you may still not know, and you learn that you pay a different price, then you may still not know that people with a certain skin color pay generally a different price. So that is one weak point. Another weak point is, as we saw, the ban on indirect discrimination. It is very nuanced, which is good, but it also makes it a bit vague. If I don't practice law anymore, but if a company would ask me, Frederik, are we allowed to charge different prices to different consumers? I would have to answer, well, it's not so easy to answer always yes and no. It completely depends on the circumstances. So the rule is a bit vague. And the third point, do you remember the example where poor people paid higher prices in the United States? That is painful, I think. However, non-discrimination law typically protects against discrimination on the basis of skin color, gender, sexual preference, age, handicap sometimes. But non-discrimination law typically does not protect against discriminating against the poor. So this is, yeah, not something that non-discrimination law deals with usually. So I think we can summarize non-discrimination law in the context of AI and machine learning as completely necessary, but probably not sufficient. But I do think that non-discrimination law is absolutely necessary in a modern society. Excuse me. Now we move to data protection law. Current most important statute in Europe is the GDPR in that field, the General Data Protection Regulation. You may have heard about it. First, I want to point out that the GDPR does not only aim to protect privacy. Actually, the word privacy is never even mentioned in the whole GDPR. And it is a very long statute, a very long regulation with almost 90 provisions, but it does not mention the word privacy. Indeed, GDPR generally aims for fairness and protecting human rights when personal data are used. Indeed, the GDPR also can be helpful to mitigate discrimination risks. And I give a few examples. The GDPR is much too long to discuss fully here, but one thing that could be useful is that the GDPR requires that organizations such as companies who use personal data must be honest and transparent about what they do with personal data and why they use it. For instance, companies can explain that in a privacy notice. Before you start asking questions about it, I realized that none of us reads privacy notices. I don't either, or I only read them for research. However, they can still be useful. As I said, sometimes I read privacy notices for research, so researchers can read them. Regulators, like non-discrimination authorities and data protection authorities, can read the privacy notices. And sometimes journalists read the privacy notices too. So even if normal people don't read such long texts, it can still be helpful to learn what the company does with our personal data. And these transparency requirements could also help regulators to uncover discrimination, or at least to uncover situations in which there is a risk of discrimination. For instance, if the company says in a privacy notice, we have a computer system that helps us to find the best job application letters from all the job applications that we get, then the regulator might think, oh, that sounds risky. Let's investigate there. And some of you may have heard about this. The GDPR also has a couple of specific rules specifically on automated decision-making. You could also say on AI-driven decision-making. Sometimes that Article 22, so the rule on automated decision-making, is sometimes called the Kafka provision. The idea is the GDPR tries to protect us against mysterious black box decisions about us. I'm summarizing heavily here, but the main rule can be interpreted as follows: that we individuals, we people, may not be subjected by companies or organizations to certain types of completely automated decisions if those decisions have far-reaching effects. The original rule is longer and slightly more complicated, but this is the main idea. So a typical example would be a bank where you can apply for a mortgage online. If the bank would use a computer to decide, that would be fully automated if the computer decides about your mortgage, and it has far-reaching effects because getting a loan or not has far-reaching effects. That is prohibited, such a system, in principle, but there's an exception again. The exceptions are for, well, I don't need to discuss the exceptions here. We can do that later if you want. But if in rare situations that such fully automated decisions, so computer decisions about us, are allowed, then the individual, the victim or the consumer, can ask for human intervention. So if you apply online for a mortgage and the computer tells you, no, you don't get one, then the bank should offer the possibility that you can call or write to the bank and say, well, I know that I live in a poor neighborhood, but I actually have quite a good salary. So you can explain your case, and the bank should then have a human that looks again at the decision. That is the idea. Moreover, if such a fully automated decision with far-reaching effects is taken, so if there's an exception that allows the fully automated decision, then the GDPR offers some type of a right to explanation. The GDPR says that the organization or the company must offer meaningful information about the logic involved in the automated. So, for instance, the bank must explain how and why the computer decides to give some people a mortgage and not. However, it may be rare that this provision actually applies. A couple of reasons. The most important ones is that the GDPR rules on automated decisions have quite a narrow specific scope. For instance, the GDPR, this particular GDPR rule only applies to fully automated decisions. Well, in practice, what often happens in the modern society is that the bank employee looks at a computer and then says as a person to the client, I'm sorry, you don't get a mortgage. And that probably falls, it's not fully automated, so probably falls outside the scope of the provision. Another loophole is, or at least a reason that many automated decisions are outside the scope of this GDPR provision, is that it is only about decisions with a legal effect or a similarly significant effect. So targeted advertising, for instance, probably falls outside the scope of this provision. So I was always skeptical, like perhaps this provision is never going to be used. But I have to admit, as far as I know now, 2 court cases in Europe so far that have actually, where judges have actually applied this provision. For instance, here a case from this spring in the Netherlands. Ola is a kind of similar company to Uber, and a couple of drivers for Ola were, I think they were fired automatically by the computer, and they went to the court and said, I'm fired by a computer, my job is terminated, and they don't give an explanation. And then the judge said to Ola, the company, indeed, this is not allowed. You must explain why the computer, why the AI system took this decision. So there seems to be actually right to an explanation in practice too. Next topic within the GDPR. The GDPR requires a so-called data protection impact assessment for certain types of personal data projects, namely personal data projects that bring serious risks for human rights, such as the right to non-discrimination. And in such a data protection impact assessment, the company must map out and think of all the risks involved and map out how all these risks will be stopped or mitigated. And sometimes the conclusion after such an impact assessment must be, actually the risks are so high, we should not start this project. That also happens. And one of the risks that should be looked at is the right to non-discrimination. So this impact assessment requirement can be useful because it means that companies must think through the risks of their AI system before they apply it to real people. So GDPR also has a few weak points. One weak point is compliance must still be better. So in many companies, compliance is still sloppy. It is better than a few years ago, much better, but still compliance must be better. Also, enforcement must be better. Sometimes, like recently, Facebook got a fine of more than 200 million euros, a big amount. Nevertheless, when we can doubt whether that really scares companies like Facebook. So compliance and enforcement must become better. Another weak point is that the GDPR is such a broad law, and there are very good reasons for such a broad law. Namely, the GDPR applies as soon as an organization does something with personal data. However, because the GDPR applies to so many situations, many rules are a bit vague. And even if the idea is beautiful about that companies and organizations must explain their AI decisions, you all know it is very hard to explain AI decisions to people, especially for self-learning AI systems. With thousands of data points, such explaining a decision is not so easy. So the GDPR we can also characterize as necessary, but not sufficient. Again, I think in the modern society, it is absolutely necessary to have data protection law, something like the GDPR, but it does not solve all the problems. I'll briefly highlight that discrimination law and data protection law are not the only relevant fields of law. For instance, competition law is very important too. It can help to lessen the power, weaken the power of monopolies. There's also sector-specific laws that are specifically for certain situations that, depending on the sector, are very important. I'll give an example. In the context of criminal proceedings, all countries in the world have a version of the presumption of innocence. And in Europe, it is a human right included in the European Convention on Human Rights. And it basically means that the assumption is, in court cases, even if somebody is suspected of a crime, the assumption is always the person is innocent. So if there's doubt about the evidence, then the person should not go to jail. This is, for instance, relevant if you would build a computer system or an AI system that helps with predictive policing. The law, even human rights treaties, say in case of doubt, the person goes not to jail. So that means that certain false positives that the AI system may have should never lead to jail time for innocent people. There's a couple of more overarching conclusions. One, if a country does not have a GDPR or a similar law yet, or if a country does not have non-discrimination law yet, then it must adopt so. That is, this in practice, more than 120 countries in the world now have a law that has very many similarities to the GDPR. So that is going well. And many countries have a version of non-discrimination law too. The US, by the way, does not have a GDPR type rule yet, but as I said, 120 countries in the world, including Korea, Japan, etc., all have a GDPR type law. And if you have adopted them, then they must both be properly enforced. Serious fines, sufficient investigations, etc. Thirdly, computer scientists and lawyers must cooperate a lot, because lawyers may know how non-discrimination law works, but auditing AI systems is too difficult for lawyers. Also, regulators, they really can use help of computer scientists. Meanwhile, computer scientists know how to audit AI systems, etc., but they typically don't know about non-discrimination law, which is fair too. We can't expect computer scientists to know everything. So interdisciplinary cooperation is needed. And mostly for the lawyers, this is, there's also a need to examine whether, in addition to the GDPR and non-discrimination law, there are additional rules needed. Personally, I think yes, and then probably sector by sector. I think, for instance, that in the insurance context, there may be need for specific rules for AI, but that would be different rules than specific rules for predictive policing, for instance. So thank you very much for your attention. Looking forward to the discussion. And if you don't have enough time, you can always reach out over Twitter or over email. And all my papers are also open access, and you can find that, well, via Twitter or my university webpage. Thank you.
Thank you very much.